Judgment has been reserved in the Constitutional Court on the matter of the definition of consent under the Sexual Offences Act. Embrace Project's advocate Nazreen Rajab Butlender highlighting what she calls deep flaws in how consent is interpreted in law. She claims the current system continues to fail survivors and undermines justice. Now, the current law allows a rape accused to avoid conviction if they can show reasonable possibility of consent. Now, the defense does not require showing that consent was actually given. The latest legal action seeks confirmation of a Pretoria High Court ruling last year, which found certain provisions of the law were unconstitutional because they failed to protect the victims. Well, Rajab Butlender saying her client's case shows how gaps in the law deny justice to survivors.
She was shell-shocked and she was in a trance and she had an out-of-body experience. Her evidence was, in the Madge Court, that she said no, but that she was not sure whether he had heard her say that. She admitted that. His version was that he had heard her say a word, but that it was not stop. After the trial, which was traumatic for Ms. Holztrager, but which canvassed all of the relevant evidence, the accused was acquitted in February 2019. In its reasoning, the Magistrates' Court found that Ms. Holztrager had objectively not consented to the sexual acts, but because she had neither physically resisted or loudly protested, the state had not been able to exclude the possibility that the accused did not hear her say no, and thus had not been able to prove beyond a reasonable doubt that he knew or foresaw that she was consenting. The judgment, the Magistrates' Court judgment, is hard to read because the frustration of the magistrate is clear from the pages of that judgment. But the magistrate makes very clear that her hands were tied, that the law required an assessment of the subjective mindset of the accused and whether subjectively he knew that she consented.
Well, let's try and take this conversation forward then on today's legal arguments and what this could do for cases in the country where the court to basically uphold the Pretoria High Court's ruling from last year. Let's speak now to gender-based violence research specialist Lisa Vetten. Lisa, good evening to you. Thank you very much for your time. Let's go back into history, the history of consent and the many times that victims of gender-based violence have been failed.
Yes, I mean, I think it is important to look at how we've historically understood rape, because it helps us to think that the way things are now is not how it always has to be. And it's also useful to look at how rape is dealt with in a range of different cultures and societies, because again, that tells us that what we have now is not the way it needs to be. And I mean, just to speak very briefly, we do have examples in the world of what we would call rape-free societies. And by rape-free, we mean societies where rape is very rarely reported. It may happen, but it's seldom. And there's often very little difficulty in believing women immediately when they say that this has happened. So I think that tells us that the way we think about women's sexuality in South Africa, for example, in comparison to these other societies, and I think from English law, where we've taken a lot of our rape law from, has a problem with the thinking about women's sexuality. And a very clear example of that actually comes from our own history. A very good piece of research that looked at rape trials in the Eastern Cape from about 1840 to about 1910. And what this particular researcher found was that right in the beginning, when rape complaints were first brought to the magistrates of that time, you never ever found the men accused saying this particular individual consented, this woman consented. You only see that starting to happen right towards the end of the study period. And what that tells you is that they were learning that consent was the way that you got yourself out of a rape charge. And what that tells you is that previously, when women were making complaints of rape in terms of traditional courts and customary law, ideas of consent were not very prominent. So that should tell us, again, that the ways we think about sexuality and what we think is normal are open to revision and to rethinking, and that what we have now is an opportunity to do that kind of rethinking. And you can see the kind of rethinking going on in the fact that we have three different arguments all being put forward by different women's organizations in trying to grapple with this issue of how do we change the way we think about consent that doesn't rely on the worst stereotypes about women's sexuality.
So let's go into those three different arguments that were presented before the Constitutional Court, Lisa. Help us summarize what each said.
I'll try and do that in a very simplified way, which legal experts may object to, but I think that will just make it more digestible for your viewers. So Embrace's position is that, as we heard from Advocate Raja Budlander, is that the test is a subjective one right now. It's what did the accused person think they were doing? What was their intention? How did they understand what was going on? And if they thought that the complainant had consented, well, then they can't be convicted because that's what they believed. And what they're arguing for is that we put in an objective standard that says if anybody else looks at the situation, did they make the effort to obtain consent? And if they didn't do that, well, then we should be convicting them. And I think the problem with that, or which the other parties have argued, is that what it potentially does is it allows for what you call, or for what could be what we call negligent rape, that somebody didn't bother, that somebody didn't make the effort to try to understand properly whether somebody was really consenting and went ahead anyway. And in that sense, they're guilty of negligence by failing to take the necessary steps to check if somebody was consenting. So that's the Embrace position. CALS's position says we should just drop consent altogether from the definition. We shouldn't be keeping it at all. And what we should simply focus on instead is the nature of the circumstances in which rape occurred. And that's why we use the idea of coercive circumstances, which say that somebody might have, you need to look carefully, because somebody might have looked like they were saying yes, but if you look at the circumstances they were in, and an example might be that it was suggested to them by their boss that if they wanted to do well this year and keep their job, they really did need to be nicer to them and to consider how they could make their life easier. Yeah. That's coercive. That's threat. So that's their position. The problem with the difficulty with that particular position is that it potentially says consent still comes in through the back door, because how are you going to determine whether or not something is coercive? And it's very hard to create an exhaustive list, which may leave the door open for judges and magistrates to then come up with their own understanding of what coercion is. The third position comes from the Women's Legal Centre. And the Women's Legal Centre says, leave the definition alone. The problem here is actually with the way judges and magistrates are applying this. And here they go back to the Pistorius case, where they say, yes, it's on one basis, the understanding is a subjective one. But actually, there is a second test. It's about whether or not somebody foresees the possibility that their actions may be unwanted. And people are forgetting that part of the test and just going from, did they know? Oh, they didn't, therefore they must be acquitted. They're saying they're failing to apply that other test that says, did you foresee that what you were doing was wrong? And if you didn't, if you didn't foresee that, then you can also be foresee that your actions could be wrong, then you can still be convicted. So I hope that was clear, but those are three different positions that are being put forward. Two are saying change the law, the other is saying leave the law alone, change the thinking and understanding of those who are applying the law.
Very well explained, Lisa. So finally, therefore, I'd like for us to deal with the presumption that the Concourt comes back and says, we uphold what the Pretoria High Court had initially ruled here, and that is that consent must be given first before anybody goes ahead. If that indeed becomes the final verdict, what will that look like in practice?
Well, actually, it will have to go. What they will probably do, because what Embrace has proposed and would have to happen is that what they're suggesting is that that's the temporary option, and that the actual definition goes back to Parliament, and there are hearings around what it should be, and a period of time is given to the courts in order to be able to come up with a proper, reasonable definition that better accommodates the arguments that have been put forward and have succeeded in relation to this particular definition. So that could probably take between 1 year to 2 years, and I think that would be important, because if the courts do take that position, it's very important that they research it very carefully. And the reason I say that is because the Women's Legal Centre, as part of their arguments, looked at Canada, where many of these arguments have come from around removing ideas about what the accused believes, and their conclusion after 25 years of having these kinds of legal provisions in place was that actually it made no difference. And I think we should look at that, and they point to other things that we need to be looking at. And once again, they're pinpointing the understanding of judges and magistrates as actually being the problem. So I think we need to take the experience in other parts of the world who will they've applied this very, very carefully in whatever it is we decide to do in order to come up with a change that makes a real difference rather than just makes us feel good that we've changed law.
Lisa Vetten, thank you very much for your time and your thoughts around this. Really, really educational indeed. Thank you very much. Lisa Vetten is a specialist in the area of gender-based violence.